I'd like to begin by acknowledging the Wurundjeri peoples of the Kulin Nations upon whose land the law school stands. As you know, I'm Margaret Young, Professor here at the Melbourne Law School and one of your lecturers in Principles of Public Law. It's my great honour to welcome Melbourne Laureate Professor Hilary Charlesworth, who will speak with us for a few minutes today about her extensive experience with the International Court of Justice. I am also delighted to be working with Professor Charlesworth on an Australian Research Council project on international adjudication. We're investigating Australia's experience with the International Court of Justice. So it is a real pleasure to be bringing her to students of PPL today. So Professor Charlesworth, I have just a number of questions to run through. I'd like to begin by asking you to tell us something about your position as ad hoc judge in the Whaling case.
Yes, well, I was appointed ad hoc judge in the Whaling case on the nomination of Australia. And the ad hoc judge is a very strange creature. For those who want to look at it, it's provided for in Article 31 of the Statute of the International Court of Justice. And this is really a hangover from the practice of international adjudication. But it was decided at the time the predecessor, actually, the statute was drafted, that countries might feel more willing to submit their disputes to the court if they were able to appoint a judge to the bench who was of their nationality. Now, obviously, there are 15 judges on the ICJ of 15 different nationalities, so there is a chance that a litigant before the court would have a judge of their nationality on the court. But if there wasn't one, a country may nominate such a person. Now, at the moment, there is a very distinguished Australian judge on the court, former Professor James Crawford. So Australia wouldn't be able to do this today. But when the Whaling case, when Australia brought the Whaling case against Japan, there was actually a judge of Japanese nationality on the court, but there was no Australian. And as I say, Australia nominated me and the court duly approved that nomination.
And I see that you gave a separate opinion in the Whaling case, and that judgments of the court often contain separate opinions or dissenting opinions. Why did you choose to do this?
Well, you'll note that my separate opinion is extremely short. And I really agreed with the court's judgment on almost all the critical issues. But the reason I included a separate opinion was I thought there was this issue of some of the instruments coming out of the International Whaling Commission that I thought it was worth spending a bit more time discussing. Obviously, after the arguments were all over, the 15 judges, and in the Whaling case it was 16 because I was the ad hoc judge, 16 of us sat round, very lengthy procedure drafting the judgment. It's a very complex and in fact impressive process. But I think it's fair to say, I did try to persuade my colleagues that they could include these words in the judgment, but I clearly failed at that. So I thought it was worth adding these. I think there are, of course, judges, and of course, in the Whaling case, there were a number of dissenting judgments. So while the court is obviously aiming for the ideal would be one joint judgment of the whole court, I think it's fair to say everybody would be very happy if that occurred. But there's a recognition, as there really is in all courts, that minds can legitimately differ on legal issues.
Thank you. And as a judge, do you have any particular impression about the legal effect of a judgment on the parties?
Well, while I think it's fair to say, and of course my experience is very limited as a judge, I feel I'm quite a boutique judge in that I've been an ad hoc judge twice, so my experience is limited. But I would say in the two cases in which I've been involved at the International Court of Justice, while the court is very keen to base its judgment in legal doctrine, it's thereby, of course, hoping to persuade the parties, this is the reason you should follow what we're saying because it's got a strong foundation in law. I think it's fair to say that the court isn't trying to craft a judgment, particularly that it knows will persuade the parties. I think any court, especially an international court, probably recognises that because of the intensity of international politics, that not all of its judgments will be followed. But I think by trying to anchor it in as much legal doctrine as possible, it's trying to increase the legitimacy of the judgment.
Yes, we heard in the separate recorded video about how there is a power in the UN Charter for the Security Council to enforce ICJ judgments, but that is extremely unlikely to be used given the politics that you've mentioned. So it's very interesting to hear the judge's perspective on how to craft the judgment to try and ensure compliance. Hilary, you mentioned another case you've been involved in as an ad hoc judge. Could you tell us a little bit about that?
Yeah, well, this is an ongoing case. I think it's a fascinating case. I think any international court case is fascinating when you get into the detail. This is a case brought by the South American country Guyana against its neighbour Venezuela. And it dates back, it's a fascinating historic case because it dates back to the interpretation of an arbitral award given in 1899. So it goes back into the mists of time, and essentially it's all to do with legitimacy of the boundary between Guyana and Venezuela. And I was appointed as an ad hoc judge by Guyana. It's an interesting case. We just before Christmas in 2020, we delivered the judgment on jurisdiction. The court found that it had jurisdiction in this case. So the case was divided into two sections. The whaling case, of course, jurisdiction and the substance were considered in one case. But in this case brought by Guyana, the court, first of all, had to establish that it had jurisdiction. It's a fascinating case because the case came to the court really on a referral by the UN Secretary General. That's quite an unusual procedure in itself. So now that the court has found that it has jurisdiction, in due course, the parties will submit their memorials on the merits, and that case will be fully argued. So far, Venezuela has resisted the court's jurisdiction and has refused to participate formally in the case.
I see, and I'm sure with the current circumstances of the pandemic that your involvement is manifesting in different ways from, I guess, the conventional way of conducting proceedings. Less travel to The Hague, which might be a plus, might be a negative, depending on how you look at it. But for an Australian, I guess, the reduction in travel might be a useful thing for you.
Well, it's very interesting how quickly the court was able to move from very formal in-person procedures to, it uses the WebEx platform, and for the oral arguments on procedure, counsel beamed in from all over the world, and the various judges, I think the two time zones, Judge Robinson was sitting in Jamaica. He was, I think, up at 5 a.m. in the morning to sit on the case, whereas it was very late at night in Australia. But it's I think, a great testimony to the court's efficiency that it managed to organise those hearings in that way. This may be the way of the future.
Yes, I think all international lawyers have to get accustomed to different time zones quite early. So for students who are interested in that career, you need to be very familiar with all of the web platforms that allow you to calculate time differences and so on.
By an alarm clock.
Yes. My final question relates to advisory opinions. So you've taken us through a couple of examples of contentious disputes, but we also consider the way in which the court can deliver advisory opinions. And we have an example of the opinion on the legal consequences of the construction of a wall in the occupied Palestinian territories. Australia didn't support the court exercising jurisdiction in that case. Do you have any views about Australia's position?
Yes, well, I I should say, Margaret and I have been writing on this very issue, so it's at the forefront of our minds. But one thing that we have done is to try and track back over the years to see how has Australia treated the advisory jurisdiction of the court. And there are certainly early on, you could find some enthusiasm. I think the Australia saw itself as wanting to bolster that, again, very interesting jurisdiction, which is unfamiliar to many domestic courts. In the Wall case, of course, Australia strongly resisted the court exercising advisory jurisdiction. It said it would be, I think the term it used was that it would be a breach of judicial propriety if the court exercised its jurisdiction, which it's granted under the UN Charter, Article 96. Australia said the arguments it put were, for example, well, look, Israel isn't really appearing at these proceedings, so it's a fairly empty gesture for the court to do this. Or Australia also pointed to the fact that it thought that such a judgment might complicate the peace process in the Middle East. But my own view is I think it's disappointing that Australia didn't really contribute on the merits. I think Australia, for a middle-sized country or a smallish country, has a very fine tradition of international legal scholarship. We have government lawyers of exceptional quality. And I, for one, think that the court has made it clear over the years that it is most likely to agree to advisory opinions. It sees that as its duty under 96 of the UN Charter. And I think Australia might be better placed, instead of resisting the court delivering these advisory opinions, sort of assisting the court by making submissions on the substance and helping the court refine its arguments.
Thank you. Well, thank you for your reflections on how the court is functioning and what the judgments might mean both for contentious cases and for advisory requests. I think you've given us a lot to think about as we work through our materials for understanding the UN organs and the primary judicial organ, namely the International Court of Justice. Thank you, Professor Charlesworth, for your time today.
It's a pleasure. Thanks, Margaret, for inviting me.